At the hearing, my wife sat beside her attorney with 18 months of fabricated records and a psychologist's sworn testimony that I had lost the ability to think clearly. She looked at me from across the courtroom the way you look at something already finished. The judge turned to me and said, "Mr. Graves, if this behavioral profile stands, you will be placed under permanent guardianship. You will not make another decision for yourself or for your child." I looked at my attorney. He opened the folder. Inside was a page torn from a 7-year-old girl's diary. I said, "Your Honor, I'd like to read this aloud." My wife stood up so fast her chair hit the railing. "Please," she said. "Please. Don't. Stop. This is Dad's revenge stories. Thank you for being here. It means more than you know. Tell me in the comments. Where are you watching from? Country? City? I want to know who's in this room with me." A note before we begin. This story contains fictional elements constructed for entertainment and educational purposes. Names and settings are coincidental. But the lesson inside is one I hope stays with you. That afternoon in the courtroom, on December 14th, 2023, I sat at the respondent's table, looking like exactly what they needed me to be. 62 years old, gray at the temples, moving with the careful deliberation that men my age are expected to carry. To anyone in that room who did not know me, and several people were counting on precisely that, I appeared to be a man whose best years had already spoken for him. But if you want to understand what happened in that courtroom, the story does not begin there. It begins on an autumn evening in October of 2012, at a legal conference in Charleston, South Carolina, that I attended only because my sister made it impossible not to. I am telling you this from the front porch of a rented cottage on Tybee Island. On Christmas morning of 2024, there is an 8-year-old girl asleep in the next room. She has been asleep for approximately 40 minutes, which by her standards constitutes an act of extraordinary restraint, given that it is Christmas and she has been aware of the presence beneath the tree since 11 o'clock last night. Outside, the salt marsh holds that particular stillness that only arrives with a southern winter morning, when the air is cool enough to carry sound but too still to move it anywhere. My coffee has gone cold, and I have a story I have been waiting 12 months to tell properly. My name is Walter Graves. For 30 years, that name meant the bench. It meant federal courtrooms and case files, and the specific weight of deciding what happened to other people's lives based on the evidence they placed before me. I was appointed to the United States District Court for the Southern District of Georgia in 1991 at the age of 30. I held that seat for 3 decades. In that time, I presided over more than 4,000 cases. I sent people to prison. I returned children to parents who had lost them and removed children from parents who should not have kept them. I ruled on contracts worth more than most people will earn in several lifetimes, and I did it with the understanding that every word I wrote carried consequences I would never fully see. I was, by most professional measures, exceptionally good at what I did. I do not say that to impress you. I say it because it matters later, when someone attempted to convince a different judge that my mind had failed. What I did not have, across those 30 years, was a life that resembled anything other than the work itself. I ate dinner alone in more cities than I care to count. I missed holidays. I missed the kinds of ordinary Tuesday evenings that most people do not think to value until they have run out of them. I had built something consequential from a chair behind a bench, and the cost of that construction was a silence in every room I came home to. There is a particular kind of loneliness that accompanies authority. It does not arrive with sadness. It arrives with an absence so gradual that you mistake it for normalcy. You look up one morning and realize that every conversation you have had in the past 6 months has been procedural. Someone presenting something. Someone responding. No one simply talking. I kept a journal. I had kept one since my first year on the bench, 1991. In a leather-bound notebook my father had given me as an appointment gift. "Write down what you see, Walter," he had said. "The truth never changes, but memory does." I wrote in that journal every evening for 30 years. I wrote about cases, about the law, about the particular silence of a house that held one person and 4 generations of furniture. What I did not write about, because I did not have the language for it at the time, was the specific emptiness of being the most trusted person in most rooms I entered and one of the least known. Before 2012, I was not in a single photograph that was not professional. There was no family to be in one. My sister Carolyn called in late September of that year while I was reviewing a case file at my desk in Chambers. She had a specific way of phrasing things that made it understood the conversation was not a negotiation. "There is a legal conference in Charleston next month," she said. "You have attended exactly 0 social events in the past 18 months. You own a suit. You own a car. I have confirmed both. You are going." I almost did not. I had a trial schedule that week that could have served as a reasonable excuse if I had wanted one badly enough. But Carolyn had a way of making the cost of refusal higher than the cost of attendance. And she had been doing it since we were children. I had spent 3 decades deciding other people's futures from behind a bench. I had not yet understood what it felt like to sit on the other side. The conference was held in a hotel on Meeting Street in downtown Charleston, the kind of building that had survived long enough to become aware of its own history. Marble floors. Crown molding restored with more patience than the original builders had likely possessed. A ballroom on the 2nd floor with chandeliers that cast the particular amber light favored by institutions that understand the value of making people feel important before asking them for something. I arrived late enough to avoid the registration line and early enough to secure a position near the windows where I could observe the room without participating in it. Sparkling water. No alcohol. I had planned the evening with the efficiency I applied to most social obligations. 90 minutes. 3 conversations of professional substance. 1 appearance at the silent auction table. Then, the exit. I was 20 minutes into that schedule when a woman approached the table I had positioned myself near and asked whether the chair beside me was taken. Her name was Meredith Lane. 25 years old, she practiced financial advisory law in Savannah and had attended the conference with a colleague who had disappeared into a conversation across the room approximately 4 minutes after arriving and had not been seen since. She was looking for somewhere reasonable to stand that did not require pretending to read the program a 3rd time. She wore a dark blazer over a simple blouse. Low heels. No statement. Jewelry. She was not working the room the way young attorneys at conferences often do, moving from handshake to handshake, collecting contacts. She was watching it, cataloging how the people inside it operated. That was something different entirely. We began talking because the alternative was silence. I gave the version of myself I always gave. Federal bench. Southern District. 30 years. Most people at that point nodded with respectful distance and redirected their attention elsewhere. Meredith Lane did not redirect. She looked at me with genuine curiosity and asked a question no one had put to me in 3 decades on the bench. What does it feel like to decide someone else's future? I set my glass down. Not because the question was impolite, because it was precise. In 30 years of judicial conferences and bar association, dinners and formal receptions where people discussed the law the way they discussed weather, no one had asked me what it felt like. They asked about sentencing guidelines. They asked about caseload management and appellate trends. They asked professional questions because professional questions are safe, and safe questions do not require the person answering them to be present in any way that matters. She had asked what it felt like, as though I were a person who had feelings about the work, rather than a title that performed it. I told her more than I had intended. I described a custody case from 2008, in which I returned a 4-year-old boy to his father after 18 months of proceedings. The father stood in my courtroom holding that child and looked at me with an expression I could not classify in any professional framework I possessed. Gratitude was the closest word, but it was incomplete. It was the look of a man who had been handed back the thing he had built his entire life around by a stranger who held the authority to do so. I went home that evening and wrote about it in my journal for 2 hours. Meredith listened without interrupting. When I finished, she said, "That must be the loneliest kind of power there is. Everyone needs something from you, and no one is allowed to know you." I had not heard it phrased that way before. Sitting in that ballroom with the chandeliers casting amber light across a room full of people who had spent the evening needing things from one another, I understood that she had described my entire professional life in 2 sentences without apparent effort, as though the observation had simply been waiting for someone to make it. We talked for close to 3 hours. The law and what it was actually built to do versus what it was frequently used for. Savannah, a city she had grown up in, and I had chosen. Books, which she had opinions about that were specific and unapologetic and occasionally wrong in ways that made the conversation better rather than worse. At some point, the formal program began. We lowered our voices without stopping. At 10:45, I noticed I had not checked my phone once. I drove back to Savannah on the coastal highway with the windows down. The salt air came off the marshes the way it does on October nights in the low country. Heavy and clean, and carrying the stillness that arrives when the tide is turning, but has not yet committed to a direction. I was not thinking about cases, not the trial schedule, not the motions on my desk. I was thinking about a woman who had asked me what it felt like to do the thing I had spent my life doing, as though the answer genuinely mattered, as though I mattered, independent of the robe and the bench, and whatever authority those things carried. At 50 years old, on a highway between 2 southern cities at 11 o'clock at night, that should not have been remarkable. But it was. I had spent 3 decades being the most respected person in most rooms I entered, and one of the least seen. Meredith Lane had looked at me as though I were simply a man and had found that interesting enough to stay for 3 hours. I drove home with the lights of Charleston behind me and the marshes dark on either side, and I understood quietly that I had not known I was hungry for that until I had already tasted it. By November of the following year, Meredith Lane would become Meredith Graves. The woman standing beside me beneath the oak tree in my family's garden seemed like the answer to a question I had not known I was carrying. I believed that completely, for a very long time, for longer than the evidence would eventually support. Our wedding was held in the garden of the Graves house, beneath the oak tree my great-grandfather had planted in 1928. 30 guests. A Saturday afternoon in June when the Spanish moss hung still in air that smelled of jasmine and old wood and the particular warmth that Savannah holds in the first weeks of summer, the kind that settles into your clothes and stays. Carolyn cried during the vows. She had prepared for this by bringing 2 handkerchiefs instead of 1, which was how Carolyn approached most situations involving emotion, with logistics. My mother Ruth, 80 years old and standing straighter than anyone else in the garden, held my hand at the reception and leaned in close enough that only I could hear. "She's clever, Walter," she said. "Make sure that's enough." I took it as a compliment at the time. Ruth did not give compliments carelessly, and clever was a word she reserved for people she considered worth watching. I filed it in the category of my mother being my mother, which is to say, a woman who had never once in my memory offered an opinion she had not thought through completely before speaking it. Years later, standing in a courtroom, watching everything I had built come apart along the specific seams Ruth had identified with 2 sentences and a glass of champagne, I would understand that she had not been complimenting Meredith. She had been warning me, but warnings only work if the person receiving them is willing to hear what is actually being said, and I was not. I was 53 years old, standing in a garden I had grown up in, marrying a woman who made the rooms of my life feel occupied for the first time in decades. I was not listening for warnings. Before the wedding, Henry Ashford, my attorney and the closest thing I had to a lifelong friend outside of family, drafted a prenuptial agreement. Meredith reviewed it with her own counsel, asked 2 clarifying questions about the asset protection clauses, and signed it without making it a negotiation. I read that as straightforwardness. I respected it. What I did not think through carefully enough was the arithmetic that document created. A divorce under those prenuptial terms would yield Meredith roughly $3 to $4 million after legal fees. That is not a small amount. But it is also not $38 million. I did not consider, because I had no reason to consider, what that difference might mean to someone who one day sat down and calculated it precisely. That calculation would turn out to matter considerably. We kept the ceremony small because neither of us wanted performance. Meredith had no interest in spectacle. I had attended enough events where the production consumed the occasion to know I did not either. The right people were there. A very good caterer. Carolyn crying on schedule. It was the right kind of day. For a long time afterward, I held on to that. Meredith ran her financial advisory practice from an office on Whitaker Street, and for the first years of our marriage we settled into a rhythm that suited us both. I left early. She was usually home before I returned. On weekends we had enough of each other to remember why we had made the decision in the first place. We were both people who understood what it cost to build something, and we respected that in each other more than I had anticipated. Then, in March of 2017, Isabelle arrived. She came 2 days early on a Tuesday morning, which seemed precisely right for someone who would spend the next 7 years refusing to wait on anyone else's timeline. 6 pounds, 14 ounces. She screamed for exactly 1 moment, and then stopped and looked around the delivery room with an expression of complete unhurried assessment, as though she were already cataloging what she had to work with. I held her for the first time against my chest and sat with that weight and thought, this is what the bench was never able to give me. I had spent 30 years making consequential decisions about other people's families. Isabelle was not a decision. She was an arrival. And she rearranged every priority I held without requesting permission. She grew into someone recognizable. Stubborn in the precise sense, she would not change her position without a reason she found sufficient. Curious in the sense that she asked follow-up questions when most children had already moved on. She wanted to understand not only what happened, but why. I saw myself in that. Meredith noticed it too, and said so with a half-smile that carried the tone of a mild warning. When Izzy was 5, I gave her a composition notebook and told her what my father had told me. Write down what you see, Izzy. The truth never changes, but memory does. She took the notebook with the seriousness of a child who had just been handed a responsibility she intended to honor. She wrote in it most evenings, sometimes about school, sometimes about the dog across the street, sometimes about things she had overheard without understanding them. She wrote the way children write, without knowing which parts matter and which parts do not, which meant she wrote everything, which meant that nothing was left out. Meredith was a good mother in those years. I want to be careful about that, because what came later creates an undertow that pulls the entire record backward, and that revision would be dishonest. She read to Izzy every single night from the time Izzy could sit still for a story. Every night from 2017 through 2020. She did not hand it off when she was tired. She sat on the edge of that bed and read until Izzy's breathing slowed, then came downstairs quietly. In the fall of 2019, my mother Ruth needed surgery for a fractured wrist. She was 84, sharp as ever, and more resistant to accepting help than anyone I have encountered. Meredith drove her to Savannah Memorial at 6 in the morning on surgery day and stayed in the waiting room for 5 hours while I was on the bench, hearing a case that could not be continued. No one asked Meredith to stay. Ruth certainly did not ask. Meredith stayed anyway. When I called after recess, Ruth got on the phone before Meredith could hand it over. That wife of yours has been sitting here the entire time, she said, in the tone she used when she was impressed but did not intend to make it easy. You had better deserve it. I have spent a long time since then trying to answer honestly whether any of it was real. The reading. The 5 hours. The woman who stayed without being asked. I do not know. That is the truthful answer. The Meredith who sat with my mother that morning existed. Whatever she chose later, whatever calculation arrived later, the woman in that waiting room was not performing. Whether that was who Meredith genuinely was, or only who she believed herself to be before someone offered a different version, I cannot tell you. I have turned that question over for months. The most honest thing I can say is that it does not have a clean answer. My father died on a Tuesday morning in August of 2020, the way he had done everything else in his life, without making anyone wait. He was 86. He had lived in the Graves house for 61 of those years, and in Savannah for all of them. He had raised 2 children in rooms their grandfather had built, tended the garden beneath the oak tree his own father had planted, and held opinions about the proper way to maintain a historic home that he considered non-negotiable and everyone else considered exhausting. He was the second generation of Graves men in that house. I was the third. The morning he died, I sat beside his bed in the room where he had slept for 4 decades, and I held his hand, and I understood that the thing connecting me to the history of that house had just become my responsibility alone. What followed was not dramatic. It was quieter than that. I continued to report to chambers. I continued to hear cases and issue rulings, and perform the work the way I had always performed it, with the same precision and the same care, and the same attention to what the evidence actually said, rather than what anyone wished it would say. But somewhere beneath that performance, something had shifted. The journal entries from that autumn are shorter than any I had written in 29 years. Some evenings I wrote a single line. Some evenings I wrote nothing, Meredith noticed. She asked whether I was sleeping. She asked whether I had considered speaking with someone. She was gentle about it, and I did not question the gentleness, because the timing made it logical. My father had just died. A wife, noticing that her husband was struggling and asking whether he was all right, is not unusual. It is expected. It is caring. I took early retirement from the bench in January of 2021. 30 years, 4,000 cases. A career that had given me more than I had expected to receive from any single commitment and had taken roughly the same amount in return. I was 60 years old. I had a family, a house with a garden, and for the first time since 1991, I had mornings that belonged to no one's schedule but my own. The first months were genuinely good. I want to acknowledge that the same way I have tried to be honest about everything else. I cooked dinner most evenings. Badly at first, then adequately. I read on the front porch on long, unhurried afternoons. I drove Izzy to Savannah Day School every morning and walked her to the gate and waited through the 3 separate goodbyes she required before she would actually go through it, because the first 2 never quite resolved the matter to her satisfaction. I had missed those mornings. Not abstractly. In the particular, irretrievable sense of not being there while each one was actually happening. Now I was there. What I was slower to understand was the shift in the household's center of gravity. For the years I had been on the bench, Meredith had run everything the house required. The school logistics, the weekend plans, the invisible architecture that makes a family function without anyone recording the effort behind it. She had been the one who was always present. Now I was the one who was always present, and the space that had been entirely hers had changed shape. She was 36 years old, still building her practice, and suddenly her husband was home every single day. I understand that dynamic clearly now. At the time, I noticed it without naming it. The changes came one at a time, and each one carried a reasonable explanation within reach. Her phone appeared face down when I entered rooms she had been sitting in. Not always, but consistently enough that I registered it. Client appointments began ending later. Past 9. Sometimes past 10. She came home one evening in November, wearing a perfume I had not encountered before, and I said nothing about it. A gym membership appeared in January without prior mention. Each item individually meant nothing. Together, I kept them in a part of my mind I had decided not to examine too carefully. In February of 2022, over dinner, Meredith mentioned a clinician she had met through a professional referral, Vincent Hale, a clinical neuropsychologist. Exceptionally sharp, she said. A good professional contact for her elder law clients. She said his name once, in the tone people use when passing along an unremarkable professional note, the kind that fills 5 seconds of dinner conversation and then moves on. She said his name once, and then she never said it again. The silence after a name is louder than the name itself. I have learned that since. Through spring and into summer, the accumulation continued without announcing itself. Meredith began asking about my health with a frequency that exceeded what I had experienced from her in any previous year. Whether I was sleeping well, whether I had noticed any changes in my energy or my focus. Once, over breakfast, she asked casually whether I had been more forgetful lately. Nothing specific, she said, just something she thought she had noticed. I told her I felt fine. I told her Dr. Alderman, my physician of 15 years, would have mentioned something if there were cause for concern. She nodded and moved on. What I understand now is what those questions were actually for. Every inquiry about my memory, my energy, my sharpness, none of it was concern. It was documentation. But that piece belongs further along. She suggested I see a different doctor in April. A specialist. Someone who took a more proactive approach to cognitive health for men at my stage of life. She said it without pressure. I declined. She dropped it immediately. The dropping it troubled me more than the suggestion had. A concerned spouse presses, finds another angle. A person who needs a specific answer and can afford to wait simply files the first refusal and moves on. Thanksgiving that year was at my mother's house on Isle of Hope, the way it had always been. Ruth had lived there for 37 years, in a cottage that sat on a bluff above the marsh with a view she had never once commented on, because she considered scenery a private matter. The arrangement required no planning. We simply arrived. She had cooked more than was necessary, which was also how it had always been. Turkey, cornbread dressing, made from a recipe she had committed to memory in 1968, and had never written down because she did not believe important things should exist on paper where anyone could find them. Sweet potato casserole. Pecan pie made with bourbon she kept in a cabinet she referred to as medicinal. Meredith was good that evening. She helped in the kitchen without turning it into a gesture. She sat with Ruth after dinner and asked about the house, about the marsh, about whether the dock needed repairs before winter. She listened in the way that mattered to my mother, which is to say, she listened without performing attention. Ruth had no tolerance for people who arranged their faces into interest while their minds were somewhere else. She could detect it from across a room the way certain animals detect weather changes, through a mechanism no one had ever successfully explained to her satisfaction. Meredith made Izzy laugh twice at the table. Given the seriousness with which Izzy approached the enterprise of a formal meal, that was not nothing. After the plates were cleared, and Izzy had settled in the living room with a book she had brought specifically for this purpose because she did not trust other people's libraries, Ruth and I stood side by side at the kitchen sink. She washed. I dried. We had done this after every Thanksgiving for as long as I could remember, and the task had never required conversation. I was expecting her assessment of the pie. What she said instead, quietly, still facing the water, was something else, entirely. She measures you now, Walter. The way an appraiser measures a house before deciding what it's worth. I kept working the towel. You worry too much, Mother. Ruth set the dish into the rack. I worry precisely enough. She left it there. Ruth said the necessary thing once and did not repeat herself because she understood that the person she was addressing had already heard her. She had operated this way for as long as I had known her. One sentence, delivered without volume or drama, and then silence, because the silence was where the sentence was supposed to do its work. I drove home with Izzy asleep in the back seat and Meredith quiet beside me, and I turned those words over the entire way. Measures you. I had spent 3 decades reading people from the bench. I had built a career on understanding what someone actually intended before they had said it plainly. And my mother, a woman who had never in my memory raised a concern she had not first thought completely through, had just said something she did not say carelessly. In January, Carolyn called and asked me to meet her for coffee at a place on Broughton Street we had been going to since she moved back to Savannah in 2009. Corner table because she liked to see the door. We talked about nothing of consequence for several minutes. Then she set her cup down, and looked at me with the expression she wore when something was going to be said, regardless of whether I wanted to hear it. "Something is wrong at home, Walter. I can see it. Izzy can feel it, even if she does not have the words for it yet. You need to stop pretending you cannot see it too." She said it without drama, the tone she had always used when she had thought something through completely, before saying it aloud. "Everything is fine, Carolyn." She looked at me for a moment. "Okay." And she did not say it again. She picked up her cup, and we moved to something else. We both understood what had just happened. I had said something that was not true. She had decided once was enough. Late one evening in January, I was coming down the hallway past the guest room when I heard it through the gap of the door. A man's voice. Low, unhurried, mid-sentence. One beat before Meredith looked up and saw me standing there. The shift in the room was immediate. The way a space changes when it becomes aware of a witness. She looked up. "Client call," she said. "Ran long." I said I understood and went to our bedroom. I lay down in the dark without turning on the light and stayed there for a long time. What happened in that room was not grief. It was inventory. The same accounting I had conducted from the bench in 1,000 cases when the evidence had shifted and I needed to understand exactly where things stood before deciding what came next. The phone. The hours. The perfume. The name said once and retired. The health questions. The doctor's suggestion dropped without argument. A man's voice at 11 at night. In the guest room of my own house. I had spent enough years reading testimony to recognize the architecture of managed information. The patient construction of a version of events designed for a specific audience. I had been on the wrong side of that construction for longer than I wanted to admit. Here is something I have not told many people. For 3 months after my mother's words followed me home from Thanksgiving, I made a deliberate choice not to know. That may sound like cowardice. Perhaps it was. But there is something particular about being 61 years old and watching the structure of your life begin to move beneath you, something that makes you want, for just a little longer, to believe the foundation is still where you left it. I had spent 30 years on the bench evaluating evidence with the understanding that the truth, however uncomfortable, was always preferable to the alternative. And yet in my own house, facing my own evidence, I chose the alternative. I chose not to look. Meredith was attentive in those winter months in a way that was easy to receive as concern. She asked after my health. She monitored my sleep. She watched me in rooms the way you watch something you are tracking rather than something you are worried about, and I allowed myself to interpret the tracking as caring because the alternative required me to act, and I was not ready. Then, on a Tuesday evening in May of 2022, my 7-year-old daughter left her composition notebook on the kitchen counter, and the choice not to know ended in the handwriting of a child who did not understand which things adults need to keep hidden. Izzy had pasta sauce on her chin and a composition notebook open beside her plate. She was writing between bites, which was how she had approached dinner since I gave her the first notebook at 5. The pencil moved in short, deliberate strokes, pausing when she needed to think, and resuming when the thought had organized itself to her satisfaction. She did not rush. She had never rushed anything that involved putting words on a page. Dinner that Tuesday evening in May was unremarkable in every way that she was explaining a disagreement between 2 friends at school that afternoon. The kind of dispute that required full coverage of all parties' motivations because Izzy did not believe in incomplete accounts. She presented the facts the way I had once instructed her to present facts. In order. Without skipping the parts that were inconvenient, Meredith said the right things at the right intervals. She responded when a response was expected. She laughed once at something Izzy said that was meant to be funny and was, but the phone in her lap was doing most of her thinking for her, and she was not hearing a word. I watched her do it. The small automatic responses that filled in for actual attention. I had seen that behavior from the bench 1,000 times. Witnesses who performed engagement while their minds were constructing something else entirely. Izzy finished the story, wrote 3 more lines in her notebook, announced that she was done, and asked to be excused. She kissed me on the cheek and went upstairs for the negotiation that preceded every Tuesday bath. Meredith and I cleared the plates. We did not speak. She said she was tired. Good night. Good night. The notebook was on the kitchen counter the following morning. Izzy had left it there beside the fruit bowl, open to the most recent page, the way she sometimes left things that had simply slipped from her attention once the next thought arrived. I noticed it while pouring coffee. The handwriting was the handwriting of a 7-year-old, slanting slightly to the right the way it always did when she was writing quickly. I read the page standing at the counter with my coffee in one hand. Today, Dr. Hale came again. He told Mommy that Daddy needs to take a special test. Mommy said Daddy doesn't know yet. I don't know why it's a secret. Daddy says secrets in families are like cracks in a wall. They always get bigger. I set the coffee down. The motion was unhurried. The expression on my face did not change. In 30 years of sitting on a bench where the people before me were watching my face for any indication of which direction my thinking was moving, I had learned to let information land without letting anyone see it land. Attorneys studied my eyes during oral arguments. Defendants watched my hands during sentencing. I had trained myself, through 3 decades of practice, to receive the worst possible information. With the same external stillness, I applied to the most routine procedural matter. I use that training now. I read the page again. Then a 3rd time. Dr. Hale came again. The word again meant this was not the first visit. Daddy needs to take a special test. A test I had not been told about, arranged by someone whose name had been mentioned once at dinner and never repeated. Mommy said Daddy doesn't know yet. They were keeping it from me deliberately, and the last line, my own words, repeated back to me in the handwriting of my daughter, who had written them down because I had taught her to write down what she saw. Secrets in families are like cracks in a wall. They always get bigger. I had given her that sentence 2 years earlier. Sitting on the front porch one evening, when she asked why her friend's parents had stopped living together. I had meant it as a general principle, a piece of guidance from a father who believed in the value of honesty delivered at the level a 5-year-old could carry. She had carried it further than I had imagined. She had carried it into a composition notebook on a Tuesday evening, between bites of pasta, and she had used it to describe something she had observed in her own home without understanding that the observation constituted evidence. I placed the notebook exactly where I had found it. I took my coffee to the front porch and sat in the chair beneath the oak tree and drank it slowly. Meredith came downstairs 20 minutes later. She moved through the kitchen. I heard the refrigerator, the cabinet, the tap. She came to the porch door. Good morning. Good morning. She went back inside. Nothing in my voice had changed. Nothing in my face had shifted. I had given her nothing to work with, because I had spent 30 years giving no one anything to work with. And the skill that had served me on the bench was now serving a different purpose entirely. That evening, after Izzy was asleep and Meredith had gone to bed, and the house had settled into the long, unbroken quiet of a savannah, I took out my phone, opened the Notes application, created a file locked with a 6-digit code I had not used for anything else, and typed every word my daughter had written. I read it back once. Then again. I went to bed at midnight. I did not sleep. At 5 in the morning, I was still on my back in the dark, and I had worked through all of it. Not with emotion, with the procedural clarity I had applied to every decision that had ever actually mattered. What had been done. What it meant. What it required. I had spent 22 months looking the other way. That ended on a Tuesday in May, because a 7-year-old told the truth about something no one had thought to teach her to keep quiet. Before Meredith woke up, I made 2 phone calls. The first lasted 3 minutes. The second lasted 9. I told both people the same thing. Find everything. Find it carefully. And make sure no one knows you are looking. Children do not learn which things are secrets. until someone sits down and explains that certain things need to remain hidden. No one had explained it to Izzy, so she had simply written what she saw, between bites of pasta, in the handwriting of a child who did not know she was providing evidence. Ray Whitfield operated from a second-floor office on Drayton Street with a door that did not have his name on it. I found him through a former colleague on the bench, someone who had used his services during a judicial ethics investigation several years earlier, and told me two things: that Ray was thorough, and that he did not discuss his clients. Those were the only qualifications that mattered. I gave him the outline without names. A man I believed my wife had been involved with. Indication that he had been inside my home, specifically in private areas where he had no reason to be. I needed documentation. Photographs, locations, dates, the kind of record that could not be reinterpreted. The 3 weeks that followed were the most carefully managed performance of my adult life. I sat across from Meredith at breakfast every morning. I waved Izzy off to school. I read on the front porch on afternoons when the weather held and appeared to be exactly what Meredith needed me to appear to be. A retired man with nowhere pressing to go and nothing urgent on his mind. On mornings when she looked tired, I had her coffee ready at 8. I asked about her clients. I listened when she answered. I gave her nothing to work with. Ray called on a Saturday morning in late June. I was in the garden beneath the oak tree with a book I had read the same page of 3 times without retaining a word. He said, "I can bring it to you, or you can come to my office. Your choice." I said I would come to him. I drove downtown and took the stairs. There was a manila envelope on the desk between us, thick enough to hold 3 weeks of work. He slid it across and said nothing. Photographs. Time-stamped and geolocated. Vincent Hale's apartment building in Midtown Savannah, captured across 4 separate visits over 3 weeks. 2 hotels within 40 minutes of the city, both documented on multiple dates. A restaurant on the south side I had driven past without ever having reason to stop. Names on reservations. Parking timestamps. Lobby footage that Ray had obtained through methods I did not ask about. 3 weeks of material. Clear, sequential, and not open to interpretation. I looked through everything once. Then I closed the envelope, folded it lengthwise, and placed it in the inside pocket of my jacket. I thanked Ray. I shook his hand. I drove home. The anger I had expected, the loud, immediate kind that demands confrontation, did not arrive. What came instead was clarity. The cold, precise, entirely operational kind. I had felt it before on the bench during cases where the evidence shifted suddenly and the entire framework of the proceeding needed to be rebuilt without anyone in the courtroom seeing the reconstruction happen in real time. Clarity like that is not pleasant, but it is considerably more dangerous to the person on the other side than anger has ever been. The next morning I had Meredith's coffee ready at 8. She thanked me. I said, "Of course." That afternoon I called Margaret Chen. She was a forensic accountant I had encountered during a complex fraud case in 2016. Careful, thorough, constitutionally unable to soften a finding. She answered on the second ring. I told her I had a financial situation that needed examining, that it required discretion, and that I would explain the full scope in person. She said she had handled most kinds. I told her to come to my office the following morning. Margaret's initial findings arrived 3 weeks later. She did not deliver them gently. She had never delivered anything gently, which was precisely the reason I had hired her. The transfers ran through Meredith's Legal Consulting LLC, a legitimate operating entity with regular client fees and contractor payments passing through it, which was exactly the point. Each flagged amount had been structured to resemble an ordinary business expense, a vendor payment, a subcontractor settlement, a consulting disbursement, small enough individually to attract no scrutiny, incremental enough collectively to add up quietly over time. She walked me through it line by line. October 2021. $32,400 logged as a contractor deposit. November. $68,000 listed as a vendor settlement. December. 87,000 categorized as a consulting fee, each amount larger than the last, each tied to a receiving entity that carried no verifiable relationship to Meredith's actual legal practice. What I have traced to date, she said, is $680,000 distributed across 11 separate transfers. She paused. And Walter, I do not think this is all of it. I told her to take whatever time the work required. I drove home without the radio on. $680,000 moved in amounts designed to stay below the thresholds that trigger automatic financial review. That kind of architecture does not happen by accident. Someone who understood how forensic accountants trace irregular activity had built that transfer pattern deliberately and with patience. That evening, after the house had gone quiet, I sat at my desk and opened my laptop. I typed Vincent Hale, clinical neuropsychologist, Savannah. His professional profile loaded cleanly. Doctoral degree from Emory University. Board-certified clinical neuropsychologist with a consulting appointment at Savannah University Medical Center. His academic publications addressed something the papers called decision-making capacity assessment protocols. His name appeared across 3 separate articles, not in medical journals, in state bar publications, legal journals written for attorneys and judges, addressing the use of neuropsychological capacity evaluations as evidence in guardianship proceedings. I read that phrase and sat very still. Guardianship proceedings. I wrote 6 words on a separate piece of paper, folded it, and placed it in the front pocket of the legal pad I kept in my desk drawer. Clinical neuropsychologist. Capacity evaluation. Guardianship proceedings. Ray's photographs had confirmed what my instincts had been telling me. But confirmation is not a plan. It is simply the ground clearing beneath you, so you can see what you are standing on. What Margaret called me about 3 weeks later had nothing to do with an affair. It had to do with my money, and a legal mechanism I had spent 30 years watching others deploy from the bench, but had never once considered that anyone would attempt to use against me. Henry Ashford had practiced law in Savannah for 34 years. He was not a dramatic man. He did not raise his voice, or pace rooms, or deliver speeches about justice. He was the kind of attorney who read a document once, placed it face down on the desk, and looked at you afterward with complete unhurried stillness. In 3 decades of knowing him, I had learned that the stillness meant he had already understood something important and was deciding how much of it to say out loud. His office occupied the 2nd floor of a building on Bull Street that had been a law office since before the First World War. Ceiling fan, turning slowly. Shelves lined with volumes he had actually read, which distinguished him from most attorneys I had encountered who kept legal libraries for the same reason. Certain people kept pianos. The room smelled of old paper and the particular warmth that Savannah buildings hold through August, when the heat settles into the walls and does not leave until October. I sat across from him on a Monday morning in early August and laid out everything without editing any of it. Not in the order I might have chosen to make myself appear more perceptive. Not with the careful omission of the months I had spent deliberately choosing not to know. All of it. Beginning with Izzy's notebook in May, and ending with what Margaret had found in the accounts. The affair documented. The neuropsychologist whose published work appeared in legal journals about guardianship proceedings, the $680,000 structured to avoid detection, and a piece of paper with 6 words on it that I had not fully understood until I read a state statute at 11 o'clock at night. Henry listened without interrupting once. When I finished, he picked up a pen and drew 3 boxes on his legal pad, connected top to bottom by arrows. "Let me show you what you have described," he said. "First here, a fabricated behavioral profile. Not a single diagnosis, but something more difficult to contest. A cumulative record of observed behavioral incidents documented over months, each one individually minor, collectively building a pattern of decline, post-it reminders, missed appointments, confusion, emotional irregularity. All of it recorded by a clinician whose published expertise was constructing exactly this kind of evidentiary framework for courtroom use. Second tier. A staged incident. One documented event of sufficient severity to support a claim of danger. Physical aggression. Erratic behavior. Something that produces a medical record at an independent facility unconnected to the primary clinician. One incident, properly documented, provides the factual basis for an emergency filing. Third tier. An emergency guardianship petition filed simultaneously with a custody motion and an asset freeze. Structured as an emergency, specifically because emergency proceedings give the respondent less time to prepare, less access to standard discovery, and less opportunity to mount a defense before temporary orders are already in place. Henry set the pen down. This is what a well-constructed guardianship fraud looks like, Walter. And Dr. Hale clearly knows what it looks like, because he has studied it professionally from the inside. I asked whether we should stop them now. Confront Meredith. Freeze the accounts. He shook his head once. If you react now, Vincent adjusts his records. Meredith claims she acted out of genuine concern. You get a contested divorce, likely resolved in your favor, and they walk. No perjury charge. No criminal exposure. Nothing irreversible. He tapped the legal pad. But if you wait and let them commit fully to a legal filing, everything changes. Perjury submitted to a court is not a mistake that can be corrected. The evidence they fabricate becomes the evidence against them. I asked about the money. That is exactly why you do not touch it yet, he said. If you freeze the accounts today, they pivot. Meredith reclassifies the transfers as authorized distributions. Vincent adjusts his timeline. You have a civil dispute and nothing criminal. But if you let Margaret document every transaction from this point forward, every dollar has a paper trail with a date and a destination and a structure that tells a story. The court can order full restitution. He looked at me directly. You are not losing that money, Walter. You are documenting it. There is a number I need to give you. Because without it, what came next makes no rational sense. A divorce under the prenuptial agreement Henry had helped draft before our wedding would have yielded Meredith roughly $3 to $4 million. That is not a small amount. But full legal guardianship over an estate of $38 million, the court granted authority to manage, transfer, and make every financial and medical decision on behalf of someone declared no longer capable of making those decisions independently, is not a settlement. It is the estate itself. Without the years of litigation, without the ceiling that a prenuptial agreement places on what a spouse can claim, Henry explained how they would likely file an emergency ex parte petition, claiming I represented an immediate danger to myself or to Izzy. Under those terms, the court could issue a temporary order without notifying me in advance. Then he said the thing I did not fully understand the significance of until it mattered more than anything else in a courtroom 5 months later. Under emergency rebuttal provisions, a respondent at the subsequent show cause hearing may present counter-evidence that was gathered and fully authenticated before the petition's filing date. Without the standard pretrial discovery process, he underlined something on the pad. If your evidence is real, complete, and authenticated before they file, we present everything at the hearing, on the spot. Their emergency structure becomes ours. He gave me a list. 2 independent cognitive evaluations from separate institutions. Data from my medical-grade smartwatch. The one my cardiologist had prescribed after a transient ischemic episode in 2019. Margaret's ongoing financial documentation. And a review of the home security system I had installed in 2010. I mentioned Evelyn. Henry said, "Let her go." I said, "No. I have a better use for her." He looked at me for a long moment. Then he wrote something on the pad. Your single greatest advantage in this situation is that they believe you are exactly what you appear to be. An older man, retired, perhaps beginning to slow. Someone who would not see this coming. He paused. Are you willing to keep appearing that way for however long this takes? I thought about 30 years on the bench, 30 years of waiting for people to reveal themselves fully before rendering a decision. I have been patient my entire career, I said. I can wait a little longer. Evelyn Torres had managed the Graves household for 19 years. She knew which floorboards creaked in the hallway outside the office, which windows swelled shut in the August humidity, and which shelf in the kitchen held the bourbon I reached for only on the nights I missed my father. She had been with me since the year I was appointed to the federal bench, and in that time she had managed my schedule, my correspondence, and the daily logistics of a house that required more attention than most people understood a historic property demands. I had trusted her with more operational knowledge of my life than I trusted most people, which made what I discovered in late August both devastating and, once I recovered from the initial recognition, unusually useful. The realization came in increments. I had told only Evelyn about a follow-up appointment with Dr. Alderman in late August. It was not on any shared calendar. I had not mentioned it to Meredith, and yet that week, Meredith asked whether the appointment had gone well. She asked it in the tone of someone monitoring a situation, not someone who had heard something in passing. 2 weeks later, the pattern appeared again. I told Evelyn I had a meeting with a former colleague downtown. Meredith asked that evening whether I had enjoyed reconnecting. Light in delivery, specific in knowledge. I set a test. On a Tuesday morning in late August, I told Evelyn I would be driving to Jacksonville on Wednesday to meet with a retired judge. Gave her a departure time, a return time, asked her to hold calls. Then I called no one else and booked no trip. Wednesday morning I drove out of the neighborhood at the expected time, went 4 blocks, turned around, and parked on a street that gave me a clear sight line to the front of the house. At 10:22, Vincent Hale's gray sedan came around the corner and pulled into my driveway. Not the street. The driveway. He was inside for 1 hour and 40 minutes. Then the car backed out and drove east. I drove home 20 minutes later. Made lunch. Read on the porch. When Evelyn arrived that afternoon to drop off documents I had requested, I looked at her directly and smiled. She smiled back. Neither of us said anything beyond what the moment required. I found out later how Meredith had reached her. Evelyn's daughter had been diagnosed with a chronic autoimmune condition in 2020. The treatment was indefinite, and the bills were considerable. Meredith had quietly covered 2 of those payments beginning in early 2022, asking nothing openly in return. By the time I understood the arrangement, Evelyn had been reporting my schedule to Meredith for approximately 8 months. She had likely convinced herself it was care. That a worried wife had legitimate reasons to stay informed about her husband's health and routine. People rarely betray someone for purely financial reasons. They need a story that makes the decision feel like the right one. Meredith had provided her with one. This did not change what I needed to do. It only changed how it felt to do it. What I needed to do was turn Evelyn into a channel. Starting in September, I began placing post-it notes in visible locations throughout the house. The kitchen counter, the hallway mirror, the desk in my office. Simple reminders. Izzy pickup 3 o'clock. Dr. Alderman Tuesday. Keys. Front table. Do not leave without. The notes themselves were unremarkable. What they represented to a clinical neuropsychologist who built behavioral documentation for legal proceedings was clinically significant. A person using external written reminders for tasks they previously managed without assistance is exhibiting what clinicians call early compensatory behavior, one of the first observable markers of cognitive support becoming necessary. Vincent Hale would recognize that pattern immediately. He would log it. I placed the notes where Evelyn would see them. She reported to Meredith. Meredith relayed to Vincent. Vincent added the observation to the record he was constructing. The most efficient piece of misdirection I ran during that entire period. It cost me nothing, and gave them exactly what they needed to keep believing I was declining. The security system required more delicate handling. The house had been equipped with a comprehensive monitoring system in 2010, following a threat I received from a defendant whose case I had presided over. Cameras at the entrances and in common areas, motion sensors, and microphones integrated into the existing fixtures in the living room and hallway, capable of capturing clear audio at conversational distance. The entire system fed to a dedicated server installed in the utility closet behind the water heater. A local network, physically wired, no wireless signal, no internet connection. Meredith knew about the cameras. She had checked the household network twice over the years. Both times, the wireless scan returned the expected devices. The wired server sat on its own isolated physical network, invisible to any wireless query. She had never had reason to open the utility closet. I had never given her one. What she did not know about were the microphones. The cameras recorded movement. The microphones recorded conversation. That distinction would matter considerably. In September, I replaced the storage drives to extend the archive capacity. The system resumed recording in the common areas, with the same silent persistence it had maintained for 12 years. I confirmed the audio sensitivity levels were sufficient for clear voice capture from anywhere in the living room. Running 2 operations simultaneously with opposite requirements was the most demanding work I had ever done. The defensive operation required visible decline, post-it reminders, occasional forgetfulness, the small theater of a man who needed notes for his own front door. The offensive operation required precision, authenticated evidence gathered, without leaving a trace. Evelyn was the point where those 2 operations could collapse into each other. One inadvertent observation, a document she should not have seen, a phone call she caught a fragment of, and the entire defensive layer would need to be rebuilt from nothing. One afternoon in late September, Evelyn entered my office without knocking. She had knocked and waited for 19 years. I had 1 second. I closed the legal document on my laptop screen. I turned the notepad on my desk to its blank side. When she was fully inside the doorway, I was leaning back in my chair with the expression of someone interrupted from nothing in particular. She placed a folder on the desk and spoke through the contents. I responded at the appropriate intervals. Then I noticed her gaze rest briefly on the notepad. Half a second. The natural, involuntary attention of someone registering something at the edge of their awareness. Then she left. I sat without moving for 30 seconds after the door closed. My heart was beating faster than I wanted it to. Not because I had failed to manage the moment, because I understood exactly how thin the margin had been. On the morning of September 12, 2022, I drove myself to Savannah University Medical Center alone. I had scheduled the appointment 3 weeks earlier through a patient portal I created specifically for this purpose, using a personal email address I had opened through a separate provider and never shared with Meredith or anyone in my household. The appointment existed in no calendar Evelyn had access to. No one in my house knew it was happening. I parked in the east garage, found the elevator, and told the receptionist at the Department of Neuropsychology that I had a 9 o'clock appointment for a full cognitive evaluation. She looked at me the way receptionists in neuropsychology departments look at older men who arrive unaccompanied. The careful assessment of someone deciding whether everything is in order. I gave her my most reassuring expression and took a seat. Dr. Samuel Okafor was a compact man in his mid-40s, with the attentive manner of a clinician who had made peace long ago with being skeptical first and reassured later. He reviewed my intake form, noted that I had self-referred without a physician's recommendation, and looked up. Most patients in this department come through a referral pathway, he said. Primary care, neurology, sometimes a family member. I understand my situation is unusual, Dr. Okafor. I leaned forward. Someone is going to file a legal document in the coming months, asserting that I have significant cognitive decline. I need an independent evaluation conducted and dated before that document exists. He set his pen down. That is not a standard reason for requesting a neuropsychological battery, Mr. Graves. I assure you it is a necessary one. He held my gaze for longer than a polite pause. Then he opened the file. What followed was 4 hours of the most systematic examination of my cognitive function I had ever undergone. The mini mental state examination, covering orientation, registration, attention, recall, and language. 30 out of 30. The Montreal Cognitive Assessment. 29 out of 30. A score Dr. Okafor did not flag with any concern. The Hopkins Verbal Learning Test, evaluating how the brain encodes and retrieves new verbal information across multiple trials. 96th percentile for men in my age group. The Trail-Making Test, measuring processing speed and the capacity to shift between competing cognitive demands. 94th percentile. He ran supplementary assessments for abstract reasoning, spatial processing, and working memory. 4 hours of structured examination from independent instruments, approaching the same question from different angles and producing the same answer from each one. When it was complete, Dr. Okafor set his materials down and looked at me with the measured neutrality of a clinician who has arrived at a finding and has no intention of overstating it. Mr. Graves, you score in the 96th percentile for executive function for men your age. That figure does not require qualification. A pause. Whatever you are preparing to defend yourself against, you are medically prepared to do so. I received a 37-page evaluation report signed by Dr. Okafor and stamped with the department's institutional seal. The date of assessment appeared in 3 places: the cover page, the summary, the examiner's certification, September 12, 2022. I walked to my car in the east garage and sat there for 15 minutes without starting the engine. I am not a man who routinely stops to sit with something, but on that September morning with 37 pages in the seat beside me, I allowed myself to register one thing clearly. My mind was intact. The test said so. Whatever else was happening, the fabricated consultations, the months of financial transfers, the man who had stood in my home office and studied the architecture of everything I owned, this part was true. My mind was whole. 2 weeks later, on September 26th, I walked into Savannah General Hospital's Department of Psychiatry and sat across from Dr. Ann Whitaker. I used the same approach. Direct. Complete. Nothing omitted. She conducted a comprehensive psychiatric evaluation, covering structured clinical interviewing, cognitive screening, mood assessment, thought organization, and behavioral analysis across multiple dimensions. Her written findings stated no indicators of any cognitive disorder, neurodegenerative process, or psychiatric condition affecting decision-making capacity. Both reports were delivered to Henry Ashford the following week. He placed them in his office safe with a signed chain of custody log and a date of receipt. 2 independent evaluations, 2 separate institutions, both dated September 2022. Vincent Hale filed his behavioral profile in October of 2022. It documented 18 months of observed behavioral deterioration he claimed had been evident since July of that year. July, 2 months before my first evaluation. Here is why that sequence matters more than anything else in the profile itself. Vincent was going to tell a judge that I had been exhibiting cognitive decline since at least July of 2022. He had positioned the onset date as far back as possible to make the pattern appear more established and more severe. What he did not know was that 2 independent evaluations from September showed the 96th percentile for executive function with no indicators of any disorder. He had claimed decline beginning in July. Real evaluations from September proved otherwise. In reaching for credibility through an early onset date, he had placed himself in a chronological position he could not defend. In law, sequence is everything. September comes before October. Real evaluations precede fabricated claims. A behavioral profile, asserting deterioration from July, cannot withstand 2 independent September assessments from institutions with no reason to coordinate, conducted by clinicians who had never heard Vincent Hale's name. Science cannot be backdated. There was one more piece I needed to build. Something that required precision, complete invisibility, and the understanding that Meredith would at some point present me with a document I should never sign. In my years on the bench, I had presided over cases involving forged signatures, fraudulent contracts, and documents that appeared authentic until a forensic examiner applied the right tool at the right magnification. I had learned, through expert testimony, I had heard dozens of times, about a technique called microprinting. Characters so small they are invisible to the unaided eye, legible only under magnification of 10 times or greater. Banks use it on checks. Governments use it on currency. It is the kind of detail that exists specifically for the moment when someone needs to prove that a document is not what it appears to be. I ordered a set of fine-point technical pens through a private account, the kind used in architectural drafting and document illustration. I began practicing in the evenings, on locked scratch paper in my office, at times when Evelyn was absent and the house was quiet. The technique was simple in concept and demanding in execution. A standard signature written with the right hand in the normal fashion, and simultaneously, within the final stroke, a line of characters small enough to be invisible under standard lighting, legible only under a forensic-grade magnifying loupe. It took 3 weeks of evening practice before the motion was natural enough that an observer watching the signature would see nothing beyond an ordinary hand completing an ordinary name. I wrote the same phrase each time. Signed under duress. W. G. Dinner that evening was unremarkable. I use that word deliberately, because what happened after dinner was designed by someone who understood exactly how remarkable it needed to appear to a judge. Izzy had questions about a history project that occupied most of the table. Meredith was attentive to her, and distracted during the intervals between. I ate. I listened. I responded at the appropriate moments. The mechanics of a family dinner performed by 3 people, 2 of whom were no longer operating from the same version of the truth. I went upstairs at 9:30. I took my medications the way I had taken them every night for 2 years. A blood pressure tablet, a cardiac support prescription, and a low-dose sleep aid that Dr. Alderman had prescribed in 2021 when my sleep began breaking apart in the first months after my father's death. The pharmacy had a dispensing record with a timestamp for every refill. I had been taking the medication consistently, on the same schedule, for 22 months. The smartwatch on my wrist was a Garmin medical-grade device prescribed by my cardiologist following the transient ischemic episode in 2019. Most people understand that a device like this monitors heart rate. What most people do not know is that a contemporary medical-grade wearable contains an integrated triaxial accelerometer. It tracks 2 things simultaneously: heart rate and physical movement, both time-stamped to the second, both synchronized to the manufacturer's secure health server. The data from that night, which Dr. Alderman would later extract and certify in a formal report, is precise. 9:47 in the evening. Heart rate 56 beats per minute. Accelerometer low activity, consistent with horizontal rest. 10:21. Heart rate 53. Accelerometer near zero, consistent with deep sleep in combination with prescribed sleep medication. 3 in the morning. Heart rate 57. Near zero movement. 6:08 in the morning. Heart rate 61. Movement initiating, consistent with waking. 8 hours and 21 minutes. The accelerometer recorded 0 movement spikes above the stillness threshold. 8 hours and 21 continuous minutes of complete physical immobility. Logged, time-stamped, and stored on a server I had no ability to access or modify. I came downstairs at 6:15. Meredith was standing at the stove with her back to me, wearing a long-sleeved shirt she had not been wearing the night before. When she turned to set a cup on the counter, I saw a bruise on her left upper arm, several inches across. New. The coloring of something that had occurred in the previous 12 hours. She was moving that arm with a deliberateness that differed slightly from her ordinary range. She looked at me. I looked at her. "Good morning. Good morning." She turned back to the stove. I made toast. I read for 20 minutes. Then I put on my jacket and went for my morning walk along the same route, at the same pace I had maintained for months. From the bench at the far end of Forsyth Park, where I had been making calls I did not want made from inside the house, I dialed Henry. She made her first move. Last night, I was upstairs asleep. I have 8 hours and 21 minutes of accelerometer data, showing 0 physical movement. Dr. Alderman can extract and certify the full log. The pharmacy has time-stamped dispensing records for the sleep medication. Henry was quiet for 1 second. Good. Say nothing at home. Let Ray continue. Ray called that afternoon. Meredith had gone to an urgent care clinic on the east side of downtown at 10:45 that morning. She had reported to the intake nurse that she had stumbled and fallen against the staircase railing. The nurse documented the visit, photographed the injury, and recorded the stated cause. The report existed in a medical file that had no connection to Vincent Hale or anyone involved in the case. That evening, after Izzy had gone to bed and the house was quiet, I went to my office, opened the security system interface, and found the file I had been waiting for. A motion-activated audio recording, time-stamped 5 evenings before the bruise appeared. I had been out walking that evening and returned earlier than planned because rain arrived without warning. Coming up the front walk, I heard voices through the living room window. 2 of them. I stopped at the side gate and stood in the rain for approximately 4 minutes. I heard most of what was being said, imperfectly, filtered through glass and weather. Then, I opened the front door. Meredith said they had been reviewing some financial planning materials. I said, of course, and went upstairs. Now I opened the file the microphone had captured that same evening. The audio was considerably clearer than what I had managed from outside a wet window. Vincent's voice had a quality I could place precisely. Rehearsed. He went through each element in sequence. The behavioral profile filed in October. The documentation assembled over the preceding months. The power of attorney, and when it would be presented. The structure of the emergency petition, and why that structure was preferable to a standard filing. He spoke about my cognitive file with the clinical remove of a man discussing a patient he had never actually treated. Then Meredith said something. He's not dangerous, Vincent. He's never raised his voice in this house. A pause. That is irrelevant to the filing. Silence. Is there another way? There is a slower way. It arrives at the same number. More silence. The kind that carries weight in both directions. Okay, she said. We do it your way. I stopped the recording. I sat with those words for longer than I had planned. She had reminded me of something I had been deliberately not thinking about. That there had been a person before Vincent who sat with my 84-year-old mother for 5 hours in a waiting room because no one had asked her to. The Meredith on that recording still knew that about herself. She was using it as an argument, and Vincent answered it the way he answered everything. With arithmetic. I copied the recording to an encrypted external drive. The following morning I drove it to Henry's office. He logged the receipt, documented the chain of custody, and placed it in the safe beside the medical evaluations. Meredith was not the architect. She had been a person with real grievances and a specific financial ceiling. Found at the right point by someone who had built a professional process for converting circumstances into outcomes. Understanding that did not change what I needed to do. It changed everything about how it felt to be doing it. She knew exactly who I was. She was choosing this anyway. The filing arrived on a Monday, November 14th, 2002. Henry called me at 7:43 in the morning, which was early for him. He said, "They moved." I was sitting on the back porch with coffee, watching Izzy's school bus pull away from the corner. The oak tree had turned. Half the leaves were on the ground. Henry read me the heading over the phone. Petition for emergency guardianship over Walter Raymond Graves. Filed in the Chatham County Probate Court by Meredith Lane Graves, represented by the law office of Brandt, Callaway, and Ellis. Supporting documentation included a behavioral profile report, authored by Dr. Vincent Hale, 3 sworn declarations from unnamed household observers, medical records from Meredith's urgent care visit in October, and a supplemental affidavit describing a pattern of cognitive deterioration, emotional instability, and escalating domestic aggression. I asked Henry to read the last phrase again. He did. Escalating domestic aggression. I set my coffee on the railing and looked at the yard. The swing set Izzy used every afternoon was still moving slightly in the wind. I had built that swing set myself in the spring of 2021, measuring every bolt hole twice because Izzy had stood beside me the entire time asking questions about why the chains needed to be exactly the same length. Henry said, "Walter, are you still there?" I said, "Yes." He said, "Good, because there is more." The petition requested 3 things. First, temporary suspension of Walter Graves's legal authority over all financial accounts, property holdings, and trust instruments. Second, temporary sole custody of the minor child, Isabella Ruth Graves, transferred to the petitioner on grounds of the respondent's diminished capacity and potential for harm. Third, appointment of a court-supervised guardian ad litem to evaluate long-term placement. I had written those words myself. Not those exact words, but words like them, hundreds of times. I had signed orders granting emergency custody transfers. I had reviewed petitions identical to this one from the other side of the bench, weighed the evidence, and made the call. I knew exactly what this document was designed to do. It was designed to move fast enough that the respondent could not prepare, broad enough that the court would feel obligated to act, and vague enough that the supporting evidence did not need to be airtight. It was a strategy I had seen work. It was a strategy I had, on occasion, allowed to work. Henry came to the house at noon. He spread the filing across the dining room table, and we went through it page by page. The behavioral profile from Vincent Hale was 41 pages. It cited observations spanning July through October of 2020 I2. It described a pattern of confusion during routine conversations, an inability to manage basic financial transactions, episodes of sudden irritability followed by periods of withdrawal, and 2 incidents of physical aggression toward a household member. The profile concluded with a diagnostic impression of early-onset neurocognitive disorder, unspecified, with behavioral disturbance. I read the phrase, early-onset neurocognitive disorder, 3 times. I had no such condition. I had a 37-page independent evaluation from Dr. Page in B7 Database, Samuel Okafor dated September 12, 2021-2, showing cognitive function in the 96th percentile. I had a psychiatric clearance from Dr. Ann Whitaker, dated September 26, 2022, finding no indicators of cognitive or psychiatric disorder. I had a Garmin smartwatch log showing 8 hours and 21 minutes of uninterrupted sleep on the night the alleged physical aggression occurred. Henry pointed to the filing date, November 14th. He pointed to the hearing date, December 14th, 30 days. He said, "They want this resolved before the holidays. If the court grants temporary guardianship, reversing it will take 6 to 9 months minimum. By then, she controls the accounts, the house, and the child." I understood the math. I had done the same math in my courtroom for 30 years. Henry closed the folder and said, "We have everything we need. The question is sequence." I said, "Explain." He said, "If we present all of it at once, we overwhelm the judge. If we present it too slowly, we lose the temporary order and spend a year clawing it back. We need a single moment that makes the entire petition collapse. One piece of evidence that is so clear, so undeniable, that the judge cannot proceed." I thought about what we had. The independent medical evaluations, the forensic accounting report from Margaret Chen, the smartwatch data, the audio recording from the home security system, the surveillance photographs from Ray Whitfield, the insurance beneficiary change, the LLC transfers. Every piece was strong, Every piece was admissible. But Henry was right. A judge does not remember 12 exhibits. A judge remembers one. I said, "The diary." Henry looked at me. I said, "Izzy wrote what she saw. She wrote it in her own words, in her own handwriting, in a notebook I gave her when she was 5 years old. She did not know what it meant. She was not coached. She was not prompted. She wrote it because I told her to write down what she sees." Henry was quiet for a long time. Then he said, "That is the most dangerous piece of evidence in this case. For both sides." I said, "I know." He said, "If we use it, there is no going back. The child becomes part of the record." I said, "She is already part of the record. They put her there when they filed for custody." Henry nodded slowly. He gathered the papers and returned them to his briefcase. Before he left, he stood in the doorway and said, "I will need the original notebook. Chain of custody has to be clean. I will log it tonight." I went upstairs to Izzy's room. The notebook was on her desk, between a box of colored pencils and a paperback copy of Charlotte's Web. I opened it to the entry from May. The handwriting was large and uneven, the way a 7-year-old writes when she is concentrating hard. I read it one more time, then I closed it, placed it in a manila envelope, wrote the date on the outside, and drove it to Henry's office before 3 o'clock. That evening, Meredith came home at 6:15. She cooked dinner. She asked Izzy about school. She asked me if I had slept well. Everything was ordinary. Everything was careful. I watched her move through the kitchen, and I thought about the filing sitting in Henry's safe, alongside every other piece of evidence she did not know existed. She had built her case in silence. I had built mine in the same silence. The difference was that she believed hers was the only one. After Izzy went to bed, I sat in my study and opened my journal. I wrote one line. The hearing is set for December 14th. 30 days. I will be ready. I closed the journal and turned off the lamp. The house was quiet. Somewhere down the hall, Meredith was on the phone. I could hear the low murmur of her voice, but not the words. I did not need to hear the words. I already knew what they were planning. I had spent 30 years listening to exactly this kind of plan, from exactly this kind of distance. The difference, this time, was that I was not the judge. Henry filed our response on November 21st, exactly 7 days after the petition arrived. He filed it thin on purpose. A general denial of all allegations, a request for full evidentiary hearing, a notice of intent to present independent medical testimony. Nothing more. He said, "Let them think we are scrambling. Let them believe the 30 days are not enough." I spent the first week of December in Henry's office every morning from 8 until noon. His office was on the second floor of a converted cotton warehouse on Bay Street, with tall windows that looked out over the river. The conference table was long enough to seat 12, and by the end of that first week, every inch of it was covered. Henry organized the evidence into 4 categories: medical, financial, surveillance, and what he called the human element. The medical category held Dr. Okafor's 37-page neuropsychological evaluation, Dr. Whitaker's psychiatric clearance, Walter's complete pharmacy records from CVS showing consistent prescriptions with no changes in dosage or medication for 3 years, and the Garmin smartwatch data from October, exported into a certified digital report with timestamps verified by an independent forensic technology consultant named David Rains. The financial category held Margaret Chen's forensic accounting report. $680,000 moved through an LLC registered in Meredith's maiden name. Insurance beneficiary changes executed in August 2020 A2. Redirecting both the life insurance policy and the supplemental retirement account away from the family trust and toward Meredith individually. A timeline of wire transfers cross-referenced with Vincent Hale's billing invoices, showing that Meredith had paid Vincent a total of $41,000 across 14 separate payments between March and October of 2022. The surveillance category held Ray Whitfield's photographs, time-stamped and geotagged, documenting 11 meetings between Meredith and Vincent Hale at locations outside of any clinical setting. Coffee shops, parking lots, a bench at Forsyth Park. Ray's written report noted that in none of these meetings did Meredith appear to be a patient. The body language, Ray wrote, was collaborative. Planning posture, shoulder-to-toe shoulder, not face-to-face. And then there was the human element. The diary. The composition notebook, with the marbled, black and white cover, now sealed in an evidence bag in Henry's safe. Henry had retained a handwriting analyst named Dr. Patricia Simmons from the University of Georgia. She examined the notebook under controlled conditions on November 28th and produced a 6-page report confirming that the handwriting was consistent with a child between the ages of 6 and 8, that there were no signs of adult guidance or dictation in the letter formation, and that the pressure patterns indicated the writer was composing original thoughts in real time, rather than copying from a source. Henry also subpoenaed the Savannah Day school attendance records for Izzy, which confirmed she had been present at school on every date that Vincent Hale's behavioral profile cited as a date of observed domestic disturbance in the home. If Izzy was at school, she was not a witness to the alleged incidents. And if Vincent cited her presence during those incidents, he had fabricated that detail. On December 7th, 1 week before the hearing, Henry and I did a full rehearsal in his conference room. He played the role of opposing counsel. He challenged every exhibit. He questioned the chain of custody on the audio recording. He argued that the smartwatch data was self-generated and unreliable. He suggested that the independent medical evaluations had been arranged specifically to counter a future filing, which would imply premeditation and bias. I answered each challenge the way I would have expected a respondent to answer in my own courtroom. Calmly. With documentation. Without emotion. When Henry challenged the audio recording, I produced the security system installation invoice from 2019, the monthly monitoring statements, and David Rains's forensic verification confirming the file had not been edited, spliced, or altered in any way. When he challenged the smartwatch data, I produced the Garmin export certificate, the pharmacy timestamp for the evening medication, and Dr. Okafor's notation that the watch model I wore was FDA cleared for continuous cardiac monitoring. When he challenged the diary, I said, "The notebook was given to a 5-year-old child by her father, who told her to write down what she sees. She did. The handwriting expert confirms it is authentic. The content describes events the child could only have known through direct observation. No one told her what to write. No one told her what it meant." Henry sat back in his chair and said nothing for a long time. Then he said, "That is the moment. Right there. When you say those words in that voice, the case turns." I asked him what he meant by that voice. He said, "You are not angry. You are not desperate. You sound like a man who has spent 30 years weighing evidence and has simply arrived at the truth. That is the voice the judge will trust." I drove home that evening on Abercorn Street, past the squares with their live oaks and iron benches. Savannah in December has a particular quality of light. The sun drops early behind the old buildings, and the Spanish moss turns silver in the last hour before dark. I had walked under those trees for 40 years. I had driven this road after every significant ruling I ever made. Some of those rulings had separated families. Some had reunited them. I had always believed that the process itself was just, even when the outcomes were painful. Now the process was coming for me, and I had done something I never permitted in my courtroom. I had prepared not just to defend myself, but to win. There is a difference. Defense is reactive. It responds to what the other side presents. Winning requires knowing what the other side will present before they present it, and having the answer ready before the question is asked. The hearing was 7 days away. Every document was indexed. Every exhibit was numbered. Every chain of custody was logged and verified. The diary was sealed. The recording was certified. The medical reports were bound. Meredith had no idea what was waiting inside that courtroom. She had built her case on the assumption that I was the man described in Vincent Hale's 41 one-page report. Confused, declining, dangerous. She had never considered the possibility that the man she was trying to erase had spent 30 years doing exactly what she was now attempting, and that he had learned, across 4,000 cases, every way it could fail. December 14th, 2020-02. I woke at 4:51 in the morning without an alarm. The house was dark. I lay in bed for 11 minutes, listening to the furnace cycle, on and off. Then I got up, showered, and put on the charcoal suit I had worn for my last day on the bench. I had not worn it since January of 2021. It still fit. I stood in front of the bathroom mirror and adjusted the tie, a solid navy blue, and I thought about the fact that the last time I had knotted this tie, I was the one sitting above the courtroom. Today, I would be sitting below. Henry picked me up at 7:15. He drove a dark green sedan that smelled like leather and old paper. Neither of us spoke for the first 10 minutes. Then Henry said, "The exhibits are numbered 1 through 19. I will introduce them in sequence. Do not speak unless I ask you a direct question, or unless the judge addresses you. Do not look at Meredith. Do not react to anything her attorney says. You are not a husband today. You are a respondent. Respond only." I said, "I understand." He said, "I know you do. That is why I took this case." The Chatham County Probate Court is a low brick building on Montgomery Street, with fluorescent lighting and wooden benches that remind you this is not a place designed for comfort. We arrived at 8:20. The hearing was scheduled for 9. Henry carried 2 briefcases. I carried nothing. Meredith was already seated on the left side of the courtroom with her attorney, a man named Philip Brandt. I had never appeared before him, but I knew the firm. Brandt, Callaway, and Ellis handled high-wasset divorce and estate disputes. They were expensive and they were precise. Meredith was wearing a cream-colored blouse and her hair was pulled back. She looked composed. She did not look at me when I entered. Vincent Hale was seated in the second row behind her. He wore a dark suit and a green tie, and he held a leather folder on his lap. He glanced at me once, briefly, the way a doctor glances at a chart before entering a room. The judge was the Honorable Catherine Harwick. She was 58 years old, appointed 12 years prior, and I had met her once at a judicial conference in Atlanta in 2016. She was precise, methodical, and known for reading every exhibit before ruling. Henry had told me this was favorable. A judge who reads everything is a judge who finds inconsistencies. Judge Harwick entered at 9:02. She sat, opened the file, and read the case number aloud. She said, "This is a petition for emergency guardianship filed by Meredith Lane Graves regarding the respondent, Walter Raymond Graves. Mr. Brandt, you may proceed." Philip Brandt stood and spoke for 22 minutes. He was good. His voice was steady and practiced. And he built the narrative the way a carpenter builds a frame, one beam at a time, each one supporting the next. He described a man who had served with distinction on the federal bench for 3 decades, but who had, in the months following his retirement, experienced a significant and accelerating cognitive decline. He described episodes of confusion, missed appointments, unpaid bills, sudden outbursts of anger that had frightened both his wife and his young daughter. He described a night in October when the respondent had physically assaulted his wife, leaving a bruise on her left upper arm. He referenced the urgent-to-care visit. He referenced the behavioral profile prepared by Dr. Vincent Hale, a board-certified clinical neuropsychologist with 14 years of practice. He asked the court to act swiftly to protect both the minor child and the marital assets from further harm. When he finished, Judge Harwick looked at me. Then, she looked at Henry. She said, "Mr. Ashford, your response." Henry stood slowly. He buttoned his jacket. He said, "Your Honor, the respondent denies every allegation in this petition. Every one. and he does not deny them with words. He denies them with documents. Henry opened the first briefcase. He placed Exhibit 1 on the table. Dr. Samuel Okafor's 37-page neuropsychological evaluation. He said, "This evaluation was conducted on September 12, 2022, at Savannah University Medical Center. The respondent scored 30 out of 30 on the Mini Mental State Examination, 29 out of 30 on the Montreal Cognitive Assessment, 96th percentile on the Hopkins Verbal Learning Test, and 94th percentile on the Trail-Making Test." Dr. Okafor's conclusion: no evidence of cognitive impairment of any kind. He placed Exhibit 2 beside it. Dr. Ann Whitaker's psychiatric evaluation from September 26th. He said, Dr. Whitaker found no indicators of cognitive or psychiatric disorder. She noted the respondent was alert, oriented, articulate, and demonstrated above-average executive function throughout a 90-minute clinical interview. I watched Judge Harwick. She picked up both reports. She did not skim them. She turned to the summary pages and read. Then she set them down and looked at Philip Brandt. Brandt's expression did not change, but his left hand moved to the edge of the table. Henry placed Exhibit 3. The Garmin smartwatch data, certified by David Rains, forensic technology consultant. He said, "Your Honor, the petition alleges physical aggression on or about October 15th, 2022. The respondent's FDA-cleared cardiac monitor recorded continuous data on that night. Heart rate between 53 and 61 beats per minute. Accelerometer reading. 0 significant movement for 8 hours and 21 minutes. The respondent was asleep. He did not leave his bed." Henry placed Exhibit 4. The pharmacy timestamp from CVS. He said, "The respondent's blood pressure medication was filled at 6:14 p.m. on October 15th. The sleep aid was taken at approximately 9:30 p.m., consistent with the cardiac monitor's recorded onset of reduced heart rate at 9:47 p.m. Judge Harwick wrote something on her notepad. She looked at Brandt again. Brandt did not move. Henry placed Exhibit 5. Margaret Chen's Forensic Accounting Report. He said, "Your Honor, this report documents $680,000 in transfers from joint marital accounts to a limited liability company registered solely in the petitioner's maiden name. It further documents a change in insurance beneficiary executed in August 2022, redirecting both the respondent's life insurance policy and supplemental retirement account away from the family trust." The courtroom was quiet. I could hear the ventilation system above the ceiling tiles. I could hear someone in the hallway outside close a door. I looked at Meredith for the first time. Her hands were in her lap. Her fingers were interlocked. She was looking at the table in front of her. Not at the judge, not at Henry, not at me. Henry paused. He closed the first briefcase and opened the second. He said, "Your Honor, I have 14 additional exhibits, but before I continue, I would like to introduce one piece of evidence that I believe the court should consider before all others," Judge Harwick said. "Proceed." Henry reached into the second briefcase and removed a sealed evidence bag. Inside, it was a composition notebook with a black and draw-white marbled cover. Henry held the evidence bag at his side and looked at Judge Harwick. He said, "Your Honor, this is a composition notebook belonging to Isabella Ruth Graves, age 7. It was given to her by her father when she was 5 years old, with the instruction to write down what she sees. The notebook has been in continuous possession of the child since that date. It was voluntarily retrieved by the respondent on November 14th, 2022, and delivered to my office the same day. Chain of custody has been maintained and logged. A certified handwriting analyst, Dr. Patricia Simmons of the University of Georgia, has examined the notebook and confirmed that all entries are consistent with a child between the ages of 6 and 8, with no evidence of adult guidance, dictation, or copying." He paused. He placed the evidence bag on the table and opened it with gloved hands. He removed the notebook and set it flat. The marbled cover was slightly worn at the corners. There was a small sticker of a yellow star on the upper left corner that Izzy had placed there the day I gave it to her. Henry said, "Your Honor, I would like to read one entry aloud." The entry is dated May of 2022. Judge Harwick said, "You may proceed." Henry opened the notebook to the marked page. He adjusted his reading glasses. The courtroom was completely silent. I could hear Philip Brandt shift in his chair. I could hear the faint hum of the fluorescent lights above us. I did not look at Meredith. I looked at the notebook in Henry's hands. Henry read, "Today Dr. Hale came again. He talked to Mommy in the kitchen for a long time. I was in the hallway, and I could hear them, but they did not know. He told Mommy that Daddy needs to take a special test. He said if Daddy does not pass the test, Mommy can be in charge of everything. Mommy said okay. She said it like she already knew. I do not think Daddy knows about the test. I think it is a secret. Secrets in families are like cracks in a wall. They always get bigger." Henry closed the notebook. He did not say anything. He let the words sit in the room, the way a stone sits at the bottom of a pool, visible through the water, undeniable. Judge Harwick was still. She was looking at the notebook. Then she looked at Vincent Hale. He was sitting in the second row with the leather folder on his lap, and for the first time since the hearing began, his posture had changed. His shoulders had drawn inward slightly. His right hand had moved from the folder to the armrest of the bench. Judge Harwick said, "Mr. Ashford, is Dr. Hale present in this courtroom?" Henry said, "He is, Your Honor." Second row, behind the petitioner. Judge Harwick looked directly at Vincent and said, "Dr. Hale, you are not a party to this proceeding, but I want you to understand that the content of this entry, if verified, raises serious questions about the objectivity of your evaluation. I will address this further before we conclude." Vincent said nothing. He looked at Philip Brandt. Brandt did not look back. Henry then said, "Your Honor, I have one additional exhibit related to this matter. Exhibit 6, an audio recording captured by the respondent's home security system on or about October 10, 2022. The recording has been examined by David Rains, a forensic technology consultant, who has confirmed it has not been edited, spliced, or altered. I would like to play it for the court." Judge Harwick said, "Proceed." Henry connected a small device to the courtroom's speaker system. The recording lasted 2 minutes and 41 seconds. The audio quality was clear. 2 voices. One was Vincent Hale. The other was Meredith. Vincent's voice said, "The behavioral profile is complete. 41 pages. It will support the petition without additional medical testimony if we file before the end of November." Meredith's voice said, "And the physical component?" Vincent said, "One documented incident is sufficient. It does not need to be severe. A bruise, a mark, something that requires a medical visit. The urgent care record becomes part of the filing." There was a pause. Then Meredith said, "He is not dangerous, Vincent. He has never raised his hand to anyone in this house." Vincent said, "That is irrelevant to the filing. The record only needs to show that it happened. It does not need to show why." Another pause. Meredith said, "Is there another way?" Vincent said, "There is a slower way. It arrives at the same number." Meredith said, "Okay, we do it your way." The recording ended. The courtroom was silent. Not the silence of people waiting for the next thing to happen. The silence of people who have just heard something they cannot unhear. I looked at Meredith. She had not moved during the recording. Her hands were still in her lap, fingers interlocked. But her face had changed. The composure she had carried into the courtroom that morning was gone. Her lips were pressed together, and her eyes were fixed on a point somewhere on the table in front of her, as if she were trying to hold herself inside a space that no longer existed. Philip Brandt leaned toward her and whispered something. She shook her head once. A small motion, barely visible. Judge Harwick removed her glasses and set them on the bench. She said, "Mr. Brandt, I am going to give you an opportunity to respond to what the court has just heard. But I want to be clear. The recording, if authenticated, describes the deliberate fabrication of evidence in a guardianship proceeding. It describes the planning of a false allegation of domestic violence. And it describes the use of a licensed professional's credentials to manufacture a medical narrative designed to strip a citizen of his legal rights. I take all of this very seriously." Brandt stood slowly. He said, "Your Honor, we would request a brief recess to confer with our client." Judge Harwick said, "You may have 15 minutes." Brandt and Meredith left the courtroom through the side door. Vincent Hale remained in his seat. He did not move. He did not open the leather folder. He sat with both hands on the armrest and looked straight ahead at nothing. Henry leaned toward me and said quietly, "It is over." I said, "Not yet." He said, "Walter, it is over. She cannot recover from this." I said, "I know, but I want to hear the judge say it." I sat in that chair and waited. 15 minutes. The courtroom was nearly empty. A clerk typed something at her desk. A bailiff stood by the door. The fluorescent lights hummed. I thought about the morning I gave Izzy that notebook. I thought about what I told her. Write down what you see. The truth never changes, but memory does. She had written down what she saw, and now the truth was sitting on the judge's bench, in the handwriting of a 7-year-old girl who did not understand what she had recorded, but understood, somehow, that it mattered. They came back in 12 minutes, not 15. Philip Brandt held the door for Meredith. She walked to her seat without looking at anyone. She sat down and placed both hands flat on the table in front of her, palms down, fingers spread, as if she were trying to hold something steady that had already fallen. Brandt remained standing. He buttoned his jacket and addressed the bench. He said, "Your Honor, after conferring with my client, we respectfully request that the petition for emergency guardianship be withdrawn without prejudice." Judge Harwick looked at him for a long moment. Then she said, "Mr. Brandt, I am not inclined to grant a withdrawal without prejudice. The evidence presented this morning suggests that this petition was not filed in good faith. A withdrawal without prejudice would allow the petitioner to refile at a later date, and I do not believe the record supports that option. I am going to treat this as a contested hearing and issue a ruling." Brandt said, "Your Honor, with respect, my client has the right to withdraw her own petition." Judge Harwick said, "She does, but I have the discretion to note the circumstances of that withdrawal on the record, and I intend to exercise that discretion. Please be seated." Brandt sat down. He did not look at Meredith. Meredith did not look at him. Judge Harwick opened the file in front of her. She spent nearly 4 minutes reading through her notes in silence. The courtroom waited. I could hear Henry breathing beside me. I could hear the scratch of the clerk's pen. I could hear faintly traffic on Montgomery Street through the single window on the east wall. Then Judge Harwick spoke. She said, "The court has reviewed the petition filed by Meredith Lane Graves. The supporting documentation, including the behavioral profile authored by Dr. Vincent Hale, the respondent's independent medical evaluations, the forensic accounting report, the digital health records, the audio recording authenticated by a forensic technology consultant, and the diary entry of the minor child, Isabella Ruth Graves." She paused and removed her glasses. She said, "I have been on this bench for 12 years. In that time, I have presided over hundreds of guardianship proceedings. The vast majority of them involve families who are genuinely struggling with the decline of a loved one. They come to this court because they do not know what else to do. Those cases are difficult, and I treat them with the gravity they deserve." She put her glasses back on and looked directly at Meredith. She said, "This is not one of those cases," she continued. The evidence presented by the respondent is overwhelming and, in the court's view, largely uncontested. Dr. Okafor's evaluation demonstrates cognitive function well above average. Dr. Whitaker's psychiatric assessment found no disorder of any kind. The respondent's digital health data directly contradicts the allegation of physical aggression on October 15th. The Forensica accounting report reveals significant and unauthorized transfers of marital assets, and the audio recording, which the court finds credible and authenticated, contains a conversation in which the petitioner and Dr. Vincent Hale discuss the deliberate fabrication of both a behavioral profile and a false allegation of domestic violence for the explicit purpose of securing guardianship and control over the respondent's assets and child. She paused again. The courtroom was absolutely still. She said, "The petition for emergency guardianship is denied. It is denied with prejudice. The petitioner may not refile this petition or any substantially similar petition in this court." She turned a page in her notes. She said, "Furthermore, the court makes the following additional orders. First, all financial accounts, property holdings, and trust instruments currently in the name of Walter Raymond Graves or jointly held with the petitioner are to remain under the sole control of the respondent, effective immediately. Any transfers, withdrawals, or changes made after August 1st, 2022 are to be reviewed by a court-appointed forensic accountant, and any funds improperly diverted are to be restored within 60 days. She said, "Second, temporary sole custody of the minor child, Isabella Ruth Graves, is awarded to the respondent, Walter Raymond Graves, effective immediately. The petitioner may seek supervised visitation through the appropriate family court process. But this court finds that the petitioner's conduct raises serious concerns about the child's welfare in her unsupervised care." She said, "Third, the court refers the conduct of Dr. Vincent Hale to the Georgia Composite Medical Board for investigation. The behavioral profile submitted in support of this petition appears to have been prepared not as an objective clinical assessment, but as an instrument designed to achieve a predetermined legal outcome. If the board determines that Dr. Hale violated professional or ethical standards, the court expects appropriate disciplinary action." She said, "Fourth, the court refers the matter of the false urgent to care report and the fabricated allegation of domestic violence to the Chatham County District Attorney's Office for review. Filing a fraudulent petition in a court of law is not a civil matter. It is a criminal one." Judge Harwick closed the file. She looked at me. She said, "Mr. Graves, you served on the federal bench for 30 years. You know better than most people in this room what this process is supposed to protect. Today, the process worked. I am sorry it had to work against someone in your own home." I said, "Thank you, Your Honor." My voice was steady. My hands were steady. Everything inside me was steady, because I had trained it to be steady for 3 decades. But somewhere underneath that training, in a place I did not allow the courtroom to see, something was breaking. Henry placed his hand on my shoulder for exactly 2 seconds. Then he removed it and began packing the exhibits. Meredith stood. Philip Brandt gathered his papers. They walked toward the side door. As Meredith reached the door, she stopped. She turned and looked at me. It was the first time she had looked directly at me since the hearing began. Her eyes were red. Her mouth opened slightly as if she were about to say something. Then she closed it. She turned and walked through the door. Vincent Hale had already left. I had not seen him go. His seat in the second row was empty. The leather folder was gone. Henry and I walked out of the courthouse into the December air. Savannah, in mid-December, smells like cold brick and wood smoke and river water. The sun was low and the light came through the live oaks in broken lines across the sidewalk. Henry said, "I will file the custody order this afternoon. You can pick up Izzy from school." I said, "I know." I drove to Savannah Day School. I parked in the lot and waited. At 3:15, the doors opened, and children came out in groups of 2 and 3. Izzy came out holding her backpack straps with both hands, looking at the ground the way she did when she was thinking about something. She saw my car, and her face changed. She ran across the pickup lane, and I opened the door, and she climbed in and said, "Daddy, you are early." I said, "I am." She said, "Are we going home?" I said, "Yes, sweetheart. We are going home." Christmas morning, 2024. Tybee Island. I am sitting on the back porch of a rented cottage with a cup of coffee that has gone cold in my hands. The ocean is 200 yards away, and I can hear it, but I cannot see it because the morning fog has not lifted yet. Izzy is inside, asleep. She is 9 years old now, and she sleeps the way she has always slept, on her left side with one arm tucked under the pillow and the other holding whatever book she fell asleep reading the night before. Last night, it was a paperback copy of The Secret Garden. The corner of page 87 is folded down. I've been sitting here since 5:30. I do this most mornings now. Not because I cannot sleep, but because the early hours are the only hours that belong entirely to me. The rest of the day belongs to Izzy, to the house, to the slow and deliberate work of rebuilding a life that someone tried to take apart. It has been 2 years since the hearing. I will tell you what happened after, because that is part of the story too, and leaving it out would be the same as lying. Meredith moved out of the house on December 21st, 2020 at 2, 1 week after the ruling. She took her clothes, her books, and a set of silverware that had belonged to her grandmother. She did not take anything else. I did not watch her leave. I was in the kitchen with Izzy, making grilled cheese sandwiches, and I heard the front door close and the sound of a car pulling out of the driveway, and that was the end of 10 years. The divorce was finalized in March of 2023. Henry handled it. The terms were straightforward because the prenuptial agreement held, and because Meredith's attorneys, a new firm this time, did not contest anything. She received the amount specified in the original agreement, $3.4 million, and she waived all claims to the house, the trusts, and the retirement accounts. She was granted supervised visitation with Izzy, 4 hours every other Saturday, at a designated family center in Savannah. She has attended every session without exception. Vincent Hale's license was suspended by the Georgia Composite Medical Board in June of 2023, following a 7-month investigation. The board found that he had produced a fraudulent behavioral profile, engaged in a financial relationship with the petitioner that constituted a conflict of interest, and participated in the planning of a false allegation of domestic violence. The suspension was for 5 years. He did not appeal. The Chatham County District Attorney's Office reviewed the criminal referral and declined to prosecute, citing insufficient evidence of intent to defraud beyond the civil standard. Henry told me this was not unusual. I told Henry I had seen the same decision made from the bench more times than I could count. The system is imperfect. I know this better than most. Ruth passed away in April of 2023. She was 84. She died in the cottage on Isle of Hope, in the bedroom overlooking the marsh, with Carolyn beside her. I was there 20 minutes later. Ruth's hands were folded on her chest and her face was calm. And Carolyn said she had been talking about the garden that morning, about the roses she had planted in 1989, and then she had closed her eyes and not opened them again. We buried her beside my father in Bonaventure Cemetery, under a live oak that is older than the city itself. I sold the Graves house in September of 2023. I could not stay in it. Every room held 2 versions of itself, the version before and the version after. And I could not stop seeing both at the same time. The kitchen where Meredith had cooked dinner the night of the filing. The guest room where I had heard the voice through the door. The porch where Izzy had left her notebook on the counter. I sold it to a young couple from Charleston who said they loved the oak tree in the garden, the one from 1928. And I told them to take care of it because it had seen more than they would ever know. Izzy and I moved to a smaller house on East Gaston Street, 3 blocks from Forsyth Park. It has a garden with a magnolia tree and a back porch just wide enough for 2 chairs. Izzy walks to school now. She is in the 4th grade, and her teacher says she writes better than most children twice her age. She still uses composition notebooks. She is on her 7th one. I asked her once, about a year after the hearing, if she remembered writing the entry about Dr. Hale. She said she did. I asked her if she understood now what it had meant. She said, "I think so. I think it meant that Mommy was trying to make you go away." I said, "That is close enough." She said, "Daddy, are you mad at her?" I thought about this for a long time. Then I said, "I was. For a while. Now I am just careful." She nodded as if this made sense to her. Which perhaps it did, because she has always understood more than she should at her age. Then she said, "I still love her, Daddy. Is that okay?" I said, "Yes, Izzy. That is always okay. I still keep my journal. I have written in it every day since 1991. 33 years. The entries from 2020 are the longest I have ever written. The entries from 2024 are the shortest, not because there is less to say, but because the things worth saying have become simpler. This morning I wrote, "Christmas. Tybee Island. Izzy is asleep. The ocean is out there somewhere. The fog is beginning to lift now. I can see the dunes and the edge of the water and a single pelican sitting on a wooden post near the shore. The coffee is cold, but I am not going to get up yet. In about an hour, Izzy will come out in her pajamas and sit in the chair beside me and say, 'Merry Christmas, Daddy.' And I will say it back, and we will sit here together and watch the ocean finish appearing. I spent 30 years deciding other people's futures. I believed that justice was a system, that the truth could be weighed and measured and written down in a ruling. I still believe that. But I have learned something else. Justice does not repair what was broken. It only stops the breaking. The repair is slower. It happens in kitchens and classrooms and on back porches in the early morning, one ordinary day at a time. This is one of those days.